In my presentation, I'll discuss the constitutional provisions relating to international law and EU law in the Constitution of Austria. I'll cover the issue of the primacy of EU law, and I'll talk about the competence of the Constitutional Court to review the constitutionality of EU acts and its role in setting boundaries to the operation of EU law in Austria. The Constitution of Austria indicates the framework for the relationship of domestic law, international law, as well as EU law, and may be defined as open to international cooperation and supranational integration. It provides for clear legal foundations for the incorporation of international law, as well as delegation of sovereign powers to supranational organizations. Namely, its Article 9 provides for the permanent reception of international customary law and for the transfer of sovereign powers to international organizations, whereas Article 50 pertains to the conclusion of international treaties. Now, let's take a look at the constitutional foundations for the operation of EU law in the Constitution of Austria. So Austria acceded the European Union under the Federal Constitutional Law, that is the Federal Constitutional Act of the accession of Austria to the European Union. It grants the authorization to conclude the accession treaty and sets out the mode of granting consent to it by national bodies. Thereby, the Austrian legal order became open to the autonomous binding force of EU law and its primacy over the entire national law. Shortly before the entry into force of the EU accession treaty in 1994, the Austrian legislature adopted an amendment to the constitution entitled European Union, and it was then composed of 6 articles. And it currently regulates in detail the technicalities of Austria's functioning in the European Union. These provisions are commonly referred to as national constitutional law on the European Union, and they regulate the following issues pertaining to EU membership. Elections to the European Parliament, seeking a seat in the European Parliament by public employees, Austria's participation in the nomination of members of EU bodies, the participation of federal states, legislative bodies of the Federation and of the federal government in EU affairs and in the European integration, as well as the role of the federal government and national council. Also, Article 50A to 50D regulates Austria's participation in the European Stability Mechanism. And now let's move on to the review of EU law by the Constitutional Court in Austria. So in accordance with Austrian constitution, the preliminary review of international treaties and treaties amending the EU founding treaties may not be conducted before they are signed. But Article 140A of the Constitution provides for the power of the Constitutional Court to ex post review the constitutionality of international treaties, including EU treaties that have already been ratified. Consequently, the Constitutional Court may deem them unconstitutional and inapplicable, upon which neither the treaty nor the legislation that implements it may apply unless the court sets an appropriate transitional period. Also, the court is not competent to adjudicate on the constitutionality of EU law, since EU acts aren't enumerated as the subject of, or a higher level norm for review in the provisions that regulate the powers of the Constitutional Court. So EU secondary legislation may not be reviewed as it's not enumerated as the subject of review. So it doesn't fall within the category of statutes, regulations, or international agreements. It may not be the higher level norm for review either, and it's impossible to declare a national norm invalid because of its inconsistency with an EU norm. It's noteworthy that the European Charter of Fundamental Rights is an exception in the context of the constitutional review of EU law acts, because it may serve as the higher level norm for review in the case of norms whose scope of application and normative structure and precision is equal to the constitutionally guaranteed rights. Those rights those provisions which don't fulfill those requirements may not serve as the higher level norm for review. Within the scope of the application of EU law, their infringement may be examined by the Constitutional Court. And it should be noted that in this context, the Constitutional Court of Austria is the first constitutional court of the European Union, which has applied parts of the Charter as a constitutional standard of review. As for the primacy of EU law, it's not explicitly enshrined in the Constitution, but it's derived from the EU Accession Act and has been adopted in the jurisprudence of the Constitutional Court. And the Austrian Constitutional Court accepts the primacy of EU law also over constitutional law, except for the fundamental principles of the Constitution. And those principles embrace the democratic, republican, federal rule of law principles, the division of powers, and the liberal principle. These principles constitute the so-called boundaries to integration. But those principles are not unamendable, and each fundamental principle of the Constitution may be amended by way of a constitutional revision adopted in a referendum. So this means that the Austrian model doesn't envisage such a strong, irremovable constitutional identity as the German one. And there's no doctrine of constitutional identity, which could not be amended even by way of a referendum. So from the beginning of Austria's accession to the European Union, the Constitutional Court accepted without any reservation the Court of Justice's case law concerning the primacy of EU law. And also the relationship between the Austrian Constitutional Court and the Court of Justice isn't marked by any significant clashes between domestic law and EU law, since the Constitutional Court represents a favorable approach to EU law. In the event of EU secondary legislation violating the fundamental principles of the Constitution, such a collision should be resolved by common courts by making a reference for a preliminary ruling, and if that court confirms the validity of disputable provisions, then domestic courts should disapply the act of secondary legislation, which is inconsistent with the fundamental principles. Yet the constitutionality of primary law, as long as it has the form of an international agreement, may be reviewed with regard to the fundamental principles of the Constitution. And if inconsistency is declared, then that law is inapplicable, unless the treaty as an overall revision of the Constitution was adopted in a referendum. In turn, secondary legislation inconsistent with fundamental principles would be absolutely invalid, since it's not the subject of review and there's no margin of inconsistency. Absolute invalidity would also occur in the case of evident ultra-vires actions of EU bodies taken in breach of the principle of conferral, and EU ultra vires acts, which would obviously contradict the fundamental principles of the Constitution, would be regarded as absolutely invalid. And in turn, it's indicated in scholarship that if a judgment of the Court of Justice would constitute an ultra vires act, then common courts would have to ignore it, and the conflict should be resolved based on negotiations between the member state as a master of the treaties and the European Union. And also collisions between EU law and national law are settled by common courts in accordance with the principle of primacy. So that will be the end of my presentation. Thank you for your attention.